Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. In July of 2025, Brian C. Kohberger stood up in open court and pled guilty to all 5 of the serious felonies that he had been charged with in Idaho versus Kohberger, and consistent with a plea deal, agreed to waive his appellate rights to appeal his sentence, which came on the 23rd of July, 2025. Mr. Kohberger has been serving his sentence in an Idaho state prison. Judge Hippler, during the July proceedings, made reference to the fact that even though Mr. Kohberger's plea agreement stated that he was waiving rights to appeal, there was binding United States Supreme Court precedent from 2019 called Garza versus Idaho, which says otherwise, that even when a criminal defendant agrees to a plea deal with the government, there are certain exceptions that will allow that defendant to later challenge the plea deal. A Texas man by the name of Munson P. Hunter III pled guilty in 2024 to aiding and abetting wire fraud. The trial judge imposed a sentence and told Mr. Hunter, quote, "You have a right to appeal," end of quote. Hunter did appeal to the U.S. Court of Appeals for the Fifth Circuit, which oversees matters in federal courts in Texas. His appeal was dismissed, with the Fifth Circuit pointing directly to his appeal waiver in his plea deal. Hunter then went to the Supreme Court in April of 2025 and asked the justices to review his case. He asserted, amongst other things, that if his case were in the Ninth Circuit, which oversees matters in Idaho, that he might have been able to proceed with his appeal, that the Fifth Circuit's dismissal seemed to be in conflict with rulings made by other federal appellate courts that allow defendants to raise a broad spectrum of constitutional challenges to their sentences. And he pointed out specifically, if he had been in the Ninth Circuit instead of the Fifth Circuit, he would have been allowed to appeal. As the trial judge told him, he had a right to appeal, and the government did not object. The Supreme Court agreed to take on his case, and a decision is expected before the end of the 2025-2026 term in June, which may change the standard that currently exists in this country per Garza versus Idaho, that allows defendants to raise such arguments as ineffective assistance of counsel to get over the otherwise waiver of appeal that exists in many plea contracts. Prior to that time, on March 3rd, 2026, the Supreme Court will hold oral argument. We have a presentation on our sister YouTube channel. A link is included in the description to this podcast episode, where we have, for example, to how you can obtain all of the many, many filings that have flown back and forth in Hunter versus United States over the past year. You learn more about what both sides are arguing and what the questions presented to the Supreme Court will be, and also how you can listen to oral argument live, which is, in my opinion, important because the justices sometimes give clues as to how they are standing on a specific issue based on the questions that they ask at oral argument. We will continue to monitor this situation as they continue to develop. And until next time, this is Kathy. Thank you for joining us here today.